If you want to do well on contracts questions, you've got to have a very clear idea about how the material is organized. We've already considered contract formation, and we've considered defenses to formation. So, we've already established that a contract exists. Now we have to figure out what the terms of that contract are. And again, we'll see many questions, both on the multi-state and on the essays, that deal with whatever the terms of the contract are and the formation of the contract. We'll see plenty of other questions that really are focusing much more on breach and on remedies. But here, the idea about figuring out what the actual contents of the contract are really is quite important, because that's how we're going to figure out what remedies are appropriate. So, we go into the issue of contract terms and contract interpretation. With regard to contract terms, really, the basics here are not very complicated, and I can counsel you this. This is one area where people tend to study way too much and practice not nearly enough. Get the fundamentals of this stuff down quickly, as I will give them to you quickly, then go on and practice. That's how you're going to learn the real nuts and bolts about how this material is tested. With regard to contract terms, often all we're going to have to worry about are the express terms of the agreement. Now, sometimes it's going to be necessary to try to figure out what those express terms are. That's part of contract interpretation. But the easy part of figuring out a contract is looking at what's actually written there and trying to figure out what it means. More often than not, it's pretty straightforward and understandable. Where it gets a little trickier, particularly with regard to UCC contracts between merchants, is implied terms. Oftentimes, especially under the UCC, merchants will engage in a course of conduct. And it's also true that at common law, non-UCC transactions between parties that do a lot of business together will tend to develop a momentum of their own and a style of their own. And the law respects that. The law is not going to impose an unreasonable degree of rigidity on the parties. The law is here to help us understand our deals and to help us give a framework for our deals, not really so much to trip us up. So prior dealings between parties, especially UCC merchants, but not necessarily limited to those parties, are relevant. As well, the custom and usage in the industry that's involved in the dispute also are relevant, because the customs of the industry and the customs of the individual parties at the case at bar are relevant to determine implied terms. And the bottom line here is we're going to require that these parties behave reasonably. So if the parties have developed a pattern of conduct over days or months or years, we're going to hold them to stay with that basic course of conduct unless they explicitly decide to change it together. We're not going to let one party that's been acting by a customary fashion for a long time stop doing it and then claim the other party is in breach. Once again, this is an area where we have to analyze the facts presented carefully in order to make a judgment. Clearly, the biggest issue, the most commonly tested issue, and maybe to some extent the hardest issue with regard to figuring out the terms of the agreement is the parole evidence rule. Now, as someone who has spent a lot of time over the last couple of decades teaching bar exam essay writing, I have to pause here and give you a spelling hint. When we're talking about the parole evidence rule, it's spelled P-A-R-O-L. There's no E at the end. The evidence is not out of custody waiting to go back in the event of a parole violation. The parole evidence rule is the rule that says that with regard to interpreting a contract, prior conversations or contemporaneous communications of any kind that vary from the terms of the contract are inadmissible if the contract is itself a complete and final expression of the agreement that the parties reached. Got that? The parole evidence rule keeps out everything that is other than the four corners of the agreement, except when it doesn't. And there are lots of exceptions to the parole evidence rule. And I'm going to go through a few of them right now. But let me give you the basic technique about the parole evidence rule. This does not always work in all cases, but it's a substitute if you don't really know the law. Look at the facts. look at the contract and look at the parties, and look at the evidence that the party is seeking to bring in, and ask yourself this. If you're the judge in the case, would you find it helpful to figure out what's going on? And I'll suggest that the greater the indicia of fraud within these facts, the more likely it is to come in. And if we're not going to establish a fraud, there's a good chance we'll be able to establish a mistake. And remember, if we can establish a mutual mistake, that's enough to defend against the formation of the contract altogether. If we show a unilateral mistake where the other party, the non-mistaken party, has notice, again, that's a defense to enforcing the contract altogether. So parole evidence comes a little bit later down the outline than contract formation. But remember, it sort of looks back over its shoulder, and if the parole evidence shows a serious enough mistake, that could be enough to invalidate the deal altogether. But remember, don't consider parole evidence until you get to the right part of the analysis. Don't do it prematurely. Consider formation, defenses to formation, and then, as part of defenses to formation, if there's a killing statute of frauds issue, go ahead and put it in there. Otherwise, it belongs in contract interpretation. That's what comes next. Now, a few details that are fairly commonly tested on the parole evidence rule. Parole evidence is admissible to show that there is some condition precedent for the contract to come into existence at all. Obviously, that's relevant because it is the genesis of the contract. It's not really explaining the contract, it sets up the contract. Next, parole evidence is admissible to resolve ambiguity. So if there is some confusion about the subject matter, the price, or any other material term of the agreement, parole evidence is admissible to resolve ambiguities. Also, parole evidence is admissible to show that the parties spoke in code or used words in some non-traditional, non-dictionary manner. Now, many of us probably are aware of cases arising out of criminal law and procedure where parties are talking about contraband, drugs, or gambling, or some other illegal product or illegal behavior, and they use code words as a substitute for using the actual words of conspiracy. And we know that in a criminal case, the court certainly will admit evidence to show what that code meant. Well, here in contracts, sometimes the parties speak in code to protect the information from a competitor, or sometimes they've just been doing business for a long time and they clown around. Well, we're going to allow parole evidence in so that the grown-ups that are trying to sort out their problems can figure out what their real contract was all about. Parole evidence is admissible in order to show that the parties were speaking in code or using other specialized language that needs to be interpreted in order for the rest of us to understand what they were doing. Also, parole evidence is admissible to show a mistake in reducing the agreement to a writing, a scrivener's error. If all of the supporting documents show X, the contract shows Y, and a party wants to say, hey, wait a minute, it was actually X, definitely parole evidence will be allowed to come in to show that the parties made some mistake as they tried to reduce their agreement to a writing. Okay, that's about as short a discussion of the statute of frauds as you will ever hear. But I think you'll also find out it's a pretty complete discussion. Go forth and practice. You will annotate your outline a little bit with a few other details, but mostly what you'll see are examples that illustrate the ideas that I've already explained. So finally, let's spend a minute or two considering contract interpretation. We've already seen that parole evidence is admissible to help a court that's in trouble with issues regarding contract interpretation. Where we've got a situation where we're trying to interpret the contract, usually it comes up in one of a couple of ways. Either the issue presented is there a present duty to perform, or we acknowledge there's a duty and we ask ourselves, has that duty been discharged? With regard to whether or not we've got a present duty to perform, the issues that come up are very fine-line distinctions between a promise and a condition. I'm telling you, that's minutia you don't really need to bother with very much. Go out and practice and see if that distinction ever crosses your table. My guess is, odds are that it will not. But one idea that's really related to ideas of breach. Again, This really is kind of a seamless web, but it's appropriate to take it in a particular order. Where we've got a party that's seeking remedies for a breach of contract, that party coming to the table as the plaintiff has to show that they have clean hands, not just with regard to an equitable remedy, but with regard to their theory of liability. The contract plaintiff has to show that he or she has performed or is standing fully ready to perform in the instance that the other party were to stop breaching. So the non-breaching party has got to have either performed or stand fully ready to perform as soon as the other party comes to the table ready to do so. Now, whether or not a condition at issue has been satisfied is going to be judged by an objective standard, unless the actual condition itself was a subjective decision based on the feelings or the judgment of the other party. That's kind of a technical idea, and it's one I will repeat. This is an idea you're likely to encounter in practice. If the issue presented is whether or not a condition has been satisfied, we're going to judge that issue objectively unless there's something intrinsically subjective about it. And under those circumstances where a condition's satisfaction is based on the subjective judgment of a party, we're going to leave it up to that party and take care of it that way. And that's all we need to consider for these purposes on the issues of contract terms and contract interpretation. Next, we're going to turn to a part of the contracts outline that a lot of people really hate and fear, and that's the issues dealing with third-party beneficiaries, the rights of non-contracting parties. And here, I think you will find the video that you will watch will largely put you at ease. This material is not as hard as you are likely to think it is, and I will prove it in the next video.